privacy law with Kirk Nara. Kirk is a partner at Wilmer Hale. He's been focused on health, privacy, and security law for forever, for a very long time. He's been a major figure in this field. And I recently read a great piece that he wrote for the IAPP on their blog on the landscape of health privacy law and just how complicated it was. And that inspired me to hold this webinar because I wanted to talk to Kirk about what's going on in health law. It's a lot more than HIPAA, and it's very complicated. And I think we're at a really challenging time right now in health privacy. Thank you for joining us, Kirk. And I'm really excited to talk to you about this topic. I think it's fascinating, and just so much is happening in recent years. So I'd like to start with the starting point, HIPAA. I think all roads begin with HIPAA in health, even though HIPAA wasn't the first thing out there. It's the big gorilla in the room. So we can start with HIPAA, and then I want to push out and spend most of our time talking about some of the other laws and some of the challenges and some of the other things that are affecting health privacy. And so to start with HIPAA, I think it would be really helpful to start just briefly, what does HIPAA actually cover? Because I think that for folks that are not familiar with HIPAA, it's pretty complicated to understand where HIPAA begins and where HIPAA ends.
Yeah, no, happy to start there, and thank you for having me today. I do think it makes sense to get that baseline because, as you said, there's tremendous misunderstanding in the not only the general population but also in people that probably should know better in legal community and provide privacy compliance and things like that. So, I mean, the fundamental way to think about HIPAA is that it's not a privacy law. The HIPAA statute, which is where this all comes from, had to do with something called portability, which is not information portability. It was taking your health insurance coverage with you from one employer to the next employer. It was a particular problem that we had with our healthcare system in the mid-90s, where if you wanted to change jobs and you had any kind of pre-existing medical condition, you couldn't get health insurance at the new employer. And so that became an artificial restriction on the ability of people to change jobs. So Congress wanted to deal with that. And so they started the process to what became the HIPAA statute, with the single P in HIPAA standing for portability. So that was the baseline. Then we added, this is the mid-90s, the internet is just getting started. More and more health information is becoming electronic. Congress said, what if we changed our healthcare system, which is a very paper-based system where every doctor has their own forms, every hospital has their own forms, every insurance company has their own forms. Let's come up with one standard form for this electronic environment, which was, perfectly legitimate idea. We could debate whether it worked, but we're going to have a single claim form. We're going to have a single form for responses to claims and for a couple of the other key elements of the healthcare system. And then again, that was part of the law that was in the statute. And then Congress basically said, all right, we're going to have all this information that's going to be electronic. Maybe we should think about privacy and security in connection with that information. But they didn't do anything in the statute about privacy and security. They didn't know what to do yet. And so Congress gave itself 3 years to write a privacy law. Those of you who follow Congress closely probably realize that they didn't actually do what they set an obligation for themselves. So at the end of 3 years, what happened is there was a default written into the statute that made the Department of Health and Human Services write what has now become the HIPAA privacy rule and the HIPAA security rule. The only thing that they were required to do was the statute told them who could be covered by those regulations. And the kinds of businesses that could be covered by those regulations had nothing to do with privacy. They had everything to do with the companies who were involved in portability and those standard electronic transactions. So, for example, if you are a life insurance company, you don't take your life insurance with you from one employer to the next. You don't take your workers' compensation insurance with you. You get new workers' compensation insurance at your new employer. If you have automobile coverage that covers you in connection with an automobile accident, you don't take that with you from one employer to the next. So only health insurers were covered by the portability pieces. So only health insurers are subject to the HIPAA privacy rule. On the provider side, it was basically people that use these standard electronic transactions. So there are some kinds of healthcare providers who don't bill insurance at all. Back in the old days, those were people who only used paper and didn't use a computer. Now there's all kinds of healthcare providers who just don't participate in the health insurance system. And so if you don't, even today, bill health insurers electronically for your care, if you never do that, if you say to your patients, here's the bill, you pay me, you patient pay me doctor, I'll give you a receipt, you can send that off to the insurance company. If the doctor does that every time, the doctor, even today, is not covered by the HIPAA privacy rule. So what we have is a rule that applies to certain kinds of businesses in certain situations with certain data. If you had an assignment as a legislative assistant in 1996 to write a healthcare privacy law, you would have never ended up with the HIPAA rules. We only got to the HIPAA rules as a tail on a much bigger dog. And so that's the misconception. HIPAA does not cover all medical information. It covers medical information in certain contexts held by doctors, hospitals, pharmacies, health insurers. That's basically the scope of the HIPAA rules.
So then, what would cover everything else? In particular, and I know that's a very big, very hard question, but just broadly, like what else is on this landscape? What would cover, for example, the healthcare providers that don't take insurance? What would cover, companies that are gathering information about health? What's this landscape look like?
So in the first 10 or 15 years of the HIPAA world, if you wanted to be a healthcare privacy person, a lawyer, compliance, whatever it was, HIPAA was 95% of what you needed to know, and that was really all that you needed, and that was most of wasn't 100% of the law, but it was most of what you needed in reality. What we've had over the last, say, 10 years is a variety of different developments that have either intentionally tried to fill in some of those gaps that are left by HIPAA, or unintentionally picked up those gaps because they covered other kinds of things. And we can talk about that. But right now, if you're going to pretend to be a healthcare privacy person, let me just try to list the different categories. There are a couple of states that have their own mini HIPAA rules. California and Texas in particular, those laws are incredibly complicated. I would say almost impossibly complicated. It's really hard to even make sense of those laws. I don't like those laws at all, but they exist. They apply to some people who are in HIPAA. They apply to other people who aren't in HIPAA. Very confusing. Then we're starting to have state comprehensive privacy laws. That's a development basically since about 2018. Those laws all cover certain kinds of healthcare activities, healthcare information that is not subject to HIPAA. So that's another category. We're up to about 20 states in that area. We're starting to see state-specific laws that are intentionally filling the gaps. We call them consumer health laws. There's 3 or 4 of those now. There's going to be more in the future, but they are expressly designed to apply in situations where HIPAA does not apply. We have different principles on medical research. That's a whole different set of privacy laws. We have state laws in almost every state that deal with certain kinds of medical conditions, specific sensitive conditions. Many of those laws predated HIPAA. They were written in an era where HIPAA didn't exist. And it's real questions as to whether they make any sense today. We have other federal laws like the Part 2 substance abuse rules. We have the Americans with Disabilities Act. And then if you're dealing with the international community, you have obviously GDPR that applies in Europe, and other kinds of laws that are fundamentally different from how the United States works. And so it's not accurate to say there's no law for this non-HIPAA information. There may have been a point in time where there was very little law. Now there's more and more and more law. You can throw in things like the Section 5 of the FTC Act, where the FTC has authority over unfair and deceptive trade practices. They're trying to fit that into some of those gaps. The state attorneys general have similar consumer protection authorities. So what we now have is we don't have one law for non-HIPAA. We have tons of laws for non-HIPAA. They fill in lots of the gaps. They may not fill in all of the gaps. For example, Dan, you asked specifically about doctors who don't bill health insurance. It's a little hard to figure out where they fit into that, which makes the sort of compliance side of this really challenging. But the real complexity we've had in the last 10 years is more and more law for this non-HIPAA information. Sometimes people subject to HIPAA also have to follow these other laws. Lots of times it's for businesses that aren't subject to HIPAA. But what we're seeing more and more is multiple laws covering the same data depending on who has it. It might even have different laws for the same businesses depending on what they're going to do with the data that they have. So we've got different rules for different data depending on who has it, what their business model is, what they're trying to do with it, what their goals are. So it's just an increasingly complicated situation with more and more law coming in the short term. Most of the law that is directly relevant at this point in healthcare that's not HIPAA is less than 5 years old. A lot of it's less than 2 years old. And we're going to see more and more both this year and in the years ahead.
So I guess in short, a mess. But there's also, I think, the common law, the breach of confidentiality tort, a very old tort. There's the privacy torts. I think that's kind of a kind of underutilized area of law that I don't see as many cases in, but could conceivably apply. And there actually are HIPAA does not preempt. So there are instances where even though HIPAA does not have a private right of action, people use HIPAA as the standard of care in either a negligence case or a breach of confidentiality case, and use common law to then say, I get a private right of action. And so those would, I think, that could govern instances where you have the folks that aren't taking insurance. So that's the whole other layer. But a lot of the focus these days has been on the statutory action, because we've seen a lot of new statutory protections and developments here. And we're going to see even more. And so I'd love to talk about, in particular, to start with the state consumer privacy laws, which really aren't health laws. They're just general consumer laws, but they have a lot of them categorize health data as sensitive data. They define it slightly differently. But then they also have some kinds of exemptions for HIPAA. And so could you explain a little bit how those laws work and where they would kick in and where they would not kick in?
So yeah, actually, can I digress for 1 second and talk about your state, the common law point, just for a second? Yeah. I mean, if the question that someone is asked, which is often what I'm asked, is what laws do I need to comply with? I'm going to go through a set of a litany of different things that lead to specific legal requirements, specific regulatory requirements. Maybe I'm going to talk about enforcement. The common law cases tend to be not necessarily a front end set of rules about what you do or don't do. It's what's the remedy, or what happens if something bad results from what's going on. And so it's clearly part of the universe. It's something that comes up. Those are often individualized claims rather than class action claims. But absolutely, if you're trying to, if you're a healthcare business or a company that has healthcare information and you're trying to think about all the different ways in which you could have risks, that is absolutely part of the equation there. All right, so let's move on to the state laws. So, for example, let's just start with CCPA, the California Consumer Privacy Act, which is the first one of these laws. So I always use the example, if you're a California resident, there's 6 or so different regulatory regimes that apply to your information if it's healthcare information. First, you have HIPAA. If you're covered by HIPAA, you're exempted from the CCPA. So if you get privacy protection from HIPAA, you don't have privacy protection for CCPA. There's those state HIPAA-like laws, including in California. If you're subject to those laws, you're also not protected by CCPA. If you're involved in medical research, you follow the medical research rules, not CCPA. If you're not covered by those things, then CCPA kicks in. And so CCPA is going to cover essentially data about people, some of which might be healthcare data, that is held by entities that aren't subject to those other rules. So that's going to fill in very broadly a lot of the gaps that exist. Again, it's not necessarily targeted to the healthcare system. It's not targeted to how health information is used. It's not unique to healthcare, but it's going to cover a lot of that healthcare information. At the same time, CCPA doesn't cover information from nonprofits. So, for example, the breast cancer patients of Greater Washington, those kinds of social service groups, community support groups, patient support groups exist all over the country for all kinds of disease states, have lots of health information about people that have those conditions. None of them are covered by any of the state privacy laws, or virtually maybe one or two that cover nonprofits. But for the most part, nonprofits aren't covered. And most of the state privacy laws, California now an exception after an early transition period, also don't cover information that employers have about you. So employers have all kinds of health information about their employees. And other than their health insurance program, it's not covered by HIPAA. They're also not covered by those state rules. So you have to look to some other source of law to ascertain what the rules are for what an employer is able to do with the healthcare information they have. So again, you just see all these different things that are trying to come in and fill the gaps. We're also seeing a new category of state laws just in the last couple of years. The Washington My Health, My Data Act is really the first of these, but Washington law was an offshoot of the Dobbs decisions. It was a result of the Dobbs decision. It was originally designed to protect reproductive rights information in certain contexts, but the law applies much more broadly than that. And it essentially is explicitly not for HIPAA data. So it excludes everything that's subject to HIPAA. They call it a consumer health law. It's intended to protect the healthcare data about you that is not subject to HIPAA. But at the same time, it really starts to blow up what the definition of health data is. It includes, at its sort of broadest reach, it includes essentially any information that can be used to make an inference about your health. And so, for example, we're starting to see questions in a variety of contexts. If you go to a sporting goods store and you buy a lot of athletic equipment that shows you're very active, is that an inference about your health? If you go to the grocery store and you buy only healthy foods, or you buy only ice cream and Coca-Cola, or whatever it is you're buying, does that make an inference about your health? So we're starting to see very broad definitions of what health information. One of the most intriguing parts about the Washington law is definition of location data. So they define location data as personal information about your location that's within a certain distance of a healthcare facility. So I always use this example. If the Washington state law was in effect in Washington, D.C., where I live and where I'm speaking to you today, and where Dan is probably today, across the street at GW, my location data right now, if that law was in effect in Washington, D.C., would be treated as healthcare data because the GW hospital is next door to my building. It's basically between my building and Dan's building. So Dan's location information, my location information is defined under the Washington law as healthcare information. It's not healthcare information. It shows that I'm at my desk talking on a webinar, doing my Zoom calls, answering my emails. But one of the results of a lot of these laws is that we're seeing broader and broader and broader definitions of what's included in healthcare information, to the point that it's really hard to define it, and it's really hard to explain why that information is deserving of more protection than other kinds of information. So this concept that health information is a particular category of sensitive data sort of started out to make sense when we were talking about your cancer diagnosis, your HIV diagnosis, your mental health information. But when it starts to be your location, it's harder and harder and harder to do that. And that's clearly one of the complexities that we're seeing in connection with this evolving law.
See, I think the idea, as I understand it, why health why the location is that, to really track if anyone was going to seek reproductive health care. And so that was I think the idea. And I think that
absolutely. No, I mean, absolutely. And if somebody had the data of a person at an abortion clinic on a certain, you could absolutely understand why you could connect the dots to that. But to have my information when I'm sitting here doing a webinar, all be the same kind of information is just bizarre. So that's one of the challenges that we're seeing. And we're seeing, I guess the other point, and maybe Dan, this is a way to connect sort of the policy side of HIPAA compared to the policy side of the state law. We're seeing these state laws come in for totally appropriate purposes. I understand why states are reacting to the Dobbs decision and trying to protect reproductive rights information. What I think we're seeing is sort of looking at that issue in isolation and not necessarily thinking about the bigger picture, both of privacy law and the rest of the healthcare system. One of the things the HIPAA rules did, I think very well, was balance good privacy law with also having the goal of having a good working healthcare system. The people at HHS in the general counsel's office in 1999 and early 2000 who wrote those rules spent the whole time trying to come up with a good balance. They recognize, and there's a bunch of different places in the HIPAA rules where this is very explicit, they recognize that in certain situations, if they gave people too much privacy protection, it would actually be bad for the healthcare system, which is not only bad for doctors and hospitals and health insurers, but also bad for patients. And so they said, we're going to give you really good privacy protection, but maybe not the best, because we also want to have a working healthcare system. I don't see that same very broad, very complicated thinking. I don't see that in those state laws. So, for example, one of the implications of the Washington law, the result of how that plays out, is that it's now harder to find the right patients for medical research, clinical research trials. I don't think they passed that law to make it harder to find patients for clinical trials. That's just one of the results of the way that law is written. So one of the real challenges we're seeing is how to think about what health information even is at this point, and then to try to come up with a set of rules that make sense about that. I mean, the HIPAA rules also don't necessarily make sense on that. I mean, for example, under HIPAA, my name and my address, if I'm a patient of a doctor or a patient of a hospital or a health insurer member, my name and my address is protected health information under HIPAA. It's given the same protection as my cancer diagnosis or my HIV diagnosis. That's just the result of how the rules work. I mean, that's kind of a weird answer.
Yeah. Well, I think the challenge,
that's how it works.
I think I wrote a paper a few years ago on sensitive data and the fact that there really is no good way to define these categories of data. And especially in today's age of algorithms and inference, anything can be used to infer health data. The famous Target case where someone purchases a Target that had nothing to do with health suddenly gave rise to inferences that they were pregnant. And so any data can be, with today's sophisticated AI algorithms, can be used to make inferences about these categories. And we don't even have what exactly is health? Well, it's everything you eat. It could be the fact that if you eat a lot of Pez, that could have effects on your health, right? It could be, especially if you ate it all at once. There's a lot of things that, how many steps you take per day, your exercise routine, where you live, all sorts of aspects, everything you consume. And that's the problem if we're trying to define health. So HIPAA basically kind of has a very, very broad definition of what kind of would be health, but it cabins it by certain types of entities that would hold the data. So it's healthcare providers, health plans, healthcare clearinghouses. And so it's not by those. The challenge is that, for the average lay individual, you ask just a normal person on the street rather than a a weird privacy lawyer. And no person will just talk normally, right? Is my health data protected? They just kind of think they're not going to, well, who owns it? Is it a health plan? Is it a clearinghouse? Is it held by this company? Does it jump through all these weird hoops? They're going to understand. They just want to know, like, is my health data protected? I just have a simple question. Like people would ask me off the street, you're a privacy expert, right? Is my health data protected? How is it? I'm like, well, do you have like a week to sit down? I can give you a whole course on this. So that's the challenge that we face is, it seems unsatisfactory that HIPAA only covers these entities. So then we have these other laws that kind of jumping into the breach, this area, why we see this activity, especially after Dobbs, where we want to do something. But that then opens up this challenge. If you're defining it by type of data rather than by use of data or risk of harm, the challenge is that when I push risk of harm or use, that gets into a rather ambiguous area where there's some judgment calls, and so that gets messy too. And so it's tricky because whenever you have the clear rules, like HIPAA, you got a pretty clear understanding of what's covered and what's not in most cases. It's unsatisfactory because a lot gets left out. The problem is in the other case, now you have an unclear rule that can often be over-inclusive or under-inclusive, and it gets messy really, really fast. And so I guess my question is, well, then what do we do? What would be your advice to policymakers to fix all this? Do we need a federal law? Do we need better state laws? If you were king for a day, how would you? And it's a very unfair question. Like, how would you fix health privacy law? You have a minute.
It's both fair and totally unfair. I think it's much easier right now to identify the problems than it is to identify a solution. So just to be clear about that, and I often compare the regime in the United States, which is U.S. privacy law in general is unique. It's particularly unique in the health setting. You compare it to GDPR, where GDPR covers sort of all of this data. No matter, they don't distinguish based on who's holding it. It covers all the data, and it does treat health data as a category of special consideration. But it lumps health data together with a bunch of other categories, including things like whether you're a member of a trade union, which is not at all something that we think about in the same level of sensitivity here in the United States, and the same level of complexity. And so I look at GDPR as an alternative model, but not necessarily a better model. I mean, I really like the HIPAA rules where they apply. I think that the HIPAA rules were very careful and very thoughtful and very effective at drawing that balance that the HHS lawyers wanted to have between really strong privacy protection and also a good working healthcare system. I think those rules on some of the things like the way that the role that consent plays in the healthcare system, I think has potentially broader implications for a debate about a national privacy law, because essentially they've taken most of the need for consumers to consent out of the equation. So instead of having, a website privacy policy that nobody reads that says, if you continue on the website, you've consented to all this stuff, we've sort of dispensed with all of that. We don't go through that charade of consent, and HIPAA saves consent for unusual situations where you really need affirmative opt-in permission from a consumer. So I think HIPAA works really well where it applies. And as your question indicates, Dan, the problem with HIPAA is not what HIPAA does, it's what HIPAA doesn't do. And so lots of folks will say, oh, let's just make HIPAA broader. Well, that's not at all easy, because one of the benefits of the nuance that works in HIPAA is that it's very well tailored to what doctors and hospitals and health insurers do. So, for example, there's a category of uses and disclosures that are treatment, payment, and healthcare operations. Treatment is pretty straightforward. Payment of medical bills is pretty straightforward. Healthcare operations is basically the administrative activities of running a healthcare business. if you said to some of the people who are not covered by HIPAA, the Apple Watch, for example, the Apple Watch has all kinds of health information available to it. If you said to Apple Watch, okay, now you're covered by HIPAA, you can do treatment, payment, healthcare operations, their answer is going to be, we don't do any of those things. That's not what our job is. That's not helpful to us. That doesn't work for us. So it's very hard to expand HIPAA given where it started with its jurisdictional scope and how the rules were written to deal with that. So full stop, you sort of, that's you can't really do that. So could you pass a law? Yeah, we can debate state or federal for a second, but could you pass a law that is explicitly tied to health information that's not covered by HIPAA? You could try to do that. That's sort of what the Washington law started out trying to do. There were some efforts in Congress a few years ago. I think that effort has disappeared now, but there were some efforts in Congress to do that a few years ago. But then you have two problems as a result of that. Maybe two problems is better than the other problems, your number of problems you have, but you have two problems. One is you at least have two sets of rules for health data. And second, you have this question about how do you define health information? And so is that law going to cover your location data? Is it going to cover certain other kinds of information that is useful in medical situations? I can point you to studies that look at things like voting records and purchasing habits and even television viewing that is relevant to people's health in medical research and medical studies and things like that. So it is really hard to have a definition of health information that includes your location, your voting records, your purchasing habits, and what you watch on television, as well as whether you had ankle surgery last year. And so I think it's really hard to have a law that is just tailored to non-HIPAA health information. Maybe that leads to a general overall privacy law that provides good general protections for all information, including whatever we're going to define as sensitive data. That makes a lot of sense to me. I mean, there's, I think, and I know, Dan, you've spent a lot of time thinking about this over the years. I mean, I think the failure of Congress to have a good national privacy law is a meaningful failure at this point. It is really, we should have one of those laws. We should have a good, strong national privacy law. We've had some sort of we've had some isolated efforts in the last couple of years to pass one of those laws. The way those laws have been drafted, even the ones that sort of got some more attention, sadly, I don't think they're actually going to help with healthcare privacy. And there's a specific reason for that, which is all of the proposals at the federal level, or all the ones that got any meaningful attention, all have exempted entities who are subject to the HIPAA rules, much like the state comprehensive privacy laws do. But one of the things that has meant is that if the healthcare businesses, the doctors, the hospitals, health insurers, the core users of healthcare data are not involved in the federal debate about a national privacy law at all. Their position is, we have HIPAA, leave us alone. And so what that means is that to the extent there is thinking about healthcare in connection with a national privacy law, that thinking is being done by people who aren't really core users of healthcare information. And almost all of those people have other interests at stake besides just healthcare data for the national privacy law. So my concern with the way the debate has played out, if we were to even assume there's going to be a national privacy law, my concern for health is that the national privacy law will just make the health situation worse rather than better, because it's just going to add another law on top of the mess that's already there. So I think it's going to add to the mess rather than solve the mess. That doesn't have to be the answer. That just seems to be sort of where we are in the state of the play at this point. I mean, there were efforts in, I'll say, the maybe early 2021, 22 or so, to have a specific bill for non-HIPAA health data. There wasn't that much interest in that bill even at the time. Right now, that bill would get caught up even more because of abortion rights and things like that. So I don't think there's any realistic chance of that bill happening. So I said, sadly, the mess is going to continue for quite a while, and my concern is that it's actually going to get worse in the short term rather than better.
Well, I always think that's a safe prediction that, Congress won't do anything and things will get messier. I could almost make that sight unseen. Um, a point and then a question. So the point is, I think the difficulty we're in is that I think there's a kind of intuition that people have and want, which is, that health data, should be protected more than just, data about, that the fact that I bought, a Diet Coke at the supermarket. That's something I think people, well, health is so much more important. The diseases that you have or your state of your heart is more important than that. So we want to then, okay, we want to protect it then more important. So that means we have to single it out, and then singling out the data creates all sorts of problems in an age of inference where, in fact, the fact that I like Diet Coke and get Diet Coke might actually have health implications. And so we're constantly in this messy situation because we either have to protect it all one size fits all, or it has to be defined on the data, or we have to break away from defining things based on data. And then we have to go, I've always argued, go to use and risk as things, but that is really fraud. And two, it's a tougher thing to do. I just don't think the others are going to work. And I don't think we're seeing movement to do those things, except I think we see that a little bit with biometric information, that the laws on biometric information define it with a use component, because otherwise it would cover every single photograph, just looking at your face. There's so many things. So it says, biometric information used to identify people. And so there's a use component that helps. Health is a little more tricky, but because there's a lot broader uses of health data. So the question is on the way that a lot of the laws work and when they exempt HIPAA. They can either exempt the organizations themselves. So if you're a hospital, you're exempt, or they could exempt the data, because hospitals might have a lot of data that might not be HIPAA regulated. And so how do those laws typically work and do the exemption? So if you're a healthcare, I'm regulated by HIPAA, therefore I don't have to deal with these state laws, or do you for some data, but not all data? So how does the exemption work, and how does a company or organization know, like, okay, I'm safe, I'm out of this law?
When you say how does a company know, that raises one of the lines that I've been using when I talk about these issues over the years, and I'll say this and then move on to answer your question. But the current state of healthcare privacy law, in my view, is increasingly bad for consumers, also increasingly bad for businesses, and it's only good for me because people can't figure it out and they need to hire a healthcare privacy lawyer. So that's not a great answer, right? Full employment for healthcare lawyers is not necessarily a big public policy goal. You are absolutely right that those laws can exempt. I mean, first of all the state laws include an exemption like a HIPAA exemption. They exempt Graham-Leach. They exempt a number of the entities that are covered by a number of different federal privacy laws. That in and of itself is an interesting choice. I'm not, basically every state has followed California on that point. There's no magic to that. There's no requirement for a state that says that says they can't pass a law that would apply, for example, to HIPAA covered entities. HIPAA, I think you alluded to this earlier. HIPAA has a preemption standard. You can't have a state law that gives you less protection than HIPAA, but you could pass a state law that gives you more protection than HIPAA. My personal view is it's always very hard to figure out if something is higher or lower or the same. That's just a difficult standard, but you could do that. The states have not done that for whatever reason. Again, that's an open question, and that is played out for the federal bills as well. But when you think about those laws, you could exempt what is covered by HIPAA, or you could exempt an entity that's covered by HIPAA. One of the oddities of some of these laws, and it's a good number of them, is that they actually seem to exempt certain businesses for certain activities because of something like HIPAA, even in situations where HIPAA doesn't apply. That's kind of odd, right? I mean, you say you're exempted from having to follow this set of rules because of another law, but that other law doesn't actually apply in that context. That's an odd result. So not all of the laws do that. Some of the laws are very tailored to exactly where the protections of this other law exist. But we definitely have a number of the state laws, and I think it's a significant majority of the state comprehensive privacy laws that exempt more broadly than the scope of the law they are actually exempting. So that's an interesting sort of weird gap, and that I haven't really seen. I could come up with law school exam questions to try to probe that gap in the middle. I don't know. Maybe an example would be let's say a hospital has medical information because of a job application or a workers' comp case or something about an employee. The hospital might be exempt from a law that covers employee data because the hospital is subject to HIPAA, even though the data they have about a hospital employee is not in fact covered by HIPAA. So maybe that's an example. Again, we don't have that many situations like that, but that's clearly a weird component of the state laws that the exemptions are often broader than what they are exempted. And they said every time you pass a law like that, what you're doing is you're just creating multiple standards. Now, it may be okay to have multiple standards. There's nothing inherently wrong with having multiple standards. What we have in the healthcare system, perhaps because of that point you made a few minutes ago, Dan, that people expect there to be something protecting, just generally protecting their healthcare information, and you have HIPAA as such a huge percentage of the pie, where there's no consistency. There's multiple standards for almost every data in every context. So you're a California resident, you're a resident of any of these states that have a comprehensive privacy law, your data is covered by at least 5 or 6 different rules. No consumer can figure that out. It's hard for law students to figure that out. It's hard for lawyers, but no consumer can figure that out. And that doesn't seem to be a very good system.
So suppose I'm a business associate and I have a PHI and I'm an app that does all sorts of things with health, but I also have, I'm also collecting all sorts of other things that's consumer facing outside of my relationship with healthcare providers. I have a little bit where you give information with your doctor, and then I have other stuff. How would something like that then be regulated? Would it be totally exempt, or would it be bifurcated and the side that does the stuff with, but it's sort of intermingled, let's say?
No, look, that's exactly the puzzle we're talking about. And it goes, for the lawyers listening to this, it goes to sort of how you give legal advice, right? If a client came to me and said, "Hi, I'm a HIPAA business associate. I'm a HIPAA business associate for 10% of my business. The other 90% is for banks and stores and libraries and colleges, whatever. Am I covered by X law?" I can look at that law, and there are going to be a bunch of the state laws that will, on their face, seem to exempt that company from the application of the state privacy law. If that client says, "That's great, I can ignore the state law, I don't have any obligations," right? I'm not giving very good legal advice if I stop there. But at the same time, if one of the state attorneys general comes to me and says, "Your client violated our state law," I'm absolutely going to take that position and argue that their law. Now again, I think it's a bit odd that the law is written that way, but many of the laws are in fact written that way. I don't know who the highly successful first lobbyist was who got that in the California bill and has been able to get that. Whenever there's a leading state and other states follow, it always is interesting what in fact they follow. There are bits and pieces of the CCPA that have been followed and other things that haven't. There are parts of the California data breach law that have been followed, and some it's just interesting to watch that. But this point about exempting people for things that they're not actually covered by under the other law, states are. I don't know that state legislators said that's a good idea. That specific thing is a really good idea. Let's make sure we have that. But that's the result of the laws we have.
Yeah, I think that's a really bad exemption, because I could create a business where I just partner with a solo practitioner who is billing insurance. And then I say, "Hey, any company, guess what? You can become a business associate to this one doctor who then has every app as their business associate," and we then wipe out all the state law coverage.
But again, this is where you start. I mean, maybe it's not quite your common law lawsuit, but I'm going to be worried about the FTC, or at least I was going to be worried about the FTC. Maybe I don't know if the FTC, this current FTC, is going to look at that. I'm certainly going to be worried about the state attorney generals. There's a variety of other laws that I want to think about it, but again, if the first instance is, am I covered by that state law? The answer is often going to be, in your situation, no, you're not covered by that state law. Now, that's part of the problem also, is that, my clients are generally going to be businesses operating in this space. The number of times where they are making important business decisions without having any idea that they're important decisions from a regulatory perspective. I mean, the example, you mentioned apps earlier. The startup company who's got a great medical app. I'll say to them, all right, who's your customer base? Oh, we're gonna be on the App Store. We're gonna make this available to consumers. That's gonna be great. I'm like, okay, that's a bunch of particular rules you got to follow if you do that. What would you do if Aetna or the Mayo Clinic called you and wants to buy $1 million? Oh my God, that would be great. All right, that's a whole different set of rules now. And you've got, if your business model has X, Y, and Z, you can't do that if you're doing it. So they don't have any idea that is actually a meaningful choice. When their salesperson gets a nibble from the Mayo Clinic, they're going to dive on it, but they don't realize that that's actually going to have a meaningful effect on their business model, their obligations, their risks, et cetera. So that's why I think the current environment is not, the fact that it's not that helpful for consumers does not mean that it's good for businesses. I think it's bad. We're in the rare lose-lose situation at this point. I said, unless you're a privacy lawyer, but usually usually you think of some kind of zero-sum game. Here it's I don't know, whatever the opposite is. We're all losers in that combination of how the laws are working in this.
So I'd like to spend a little time kind of talking about where things are heading. And it sounds like we're heading to more of this, more time in the wilderness. And in particular, we have, the kind of this new wave of privacy laws, health privacy laws coming on, the Washington My Health, My Data Act. I think we'll probably see some other state laws. We saw a law that was passed in New York that was somewhat like the Washington law, but that's kind of in this weird state of limbo. I believe it's kind of sitting on the desk of the governor, who could send it back. Anything could happen to it. And so that's kind of somewhere. What else is kind of on the horizon that you see? I mean, obviously we'll see probably more state consumer privacy laws, but they typically follow similar models, although now we're seeing this new model from Maryland, a data minimization approach. So what do you see now for the future, given that the odds that the federal law is very unlikely?
I think we're going to see a couple of things over the next couple of years. So I think on the state, comprehensive law front, which seems to have slowed down this year, just to be clear, but we have had a few laws. Your Maryland example is probably the best one, where the general comprehensive privacy law that still tracks things like the exemptions that we've talked about also creates, in certain data categories like health data, very explicit consent requirements, which I think are going to be very hard for any company to do, even in normal situations. And so that's going to be a real challenge, watching those laws play out. That's the general comprehensive state privacy law. We're definitely going to see more of the Washington model. That's the New York example you gave. There's a couple of other states in play at this point. There was a very aggressive law in New Mexico that seems to have died at this point. But I think we're going to see more and more of those state consumer health laws. That means laws that are focused on health data, probably mutually exclusive from HIPAA, but at least are written to be specific to healthcare data. How they define it is up in the air. How broad it's going to be, all of that stuff is going to be challenging. We're also going to continue to see DOPS-related laws. We're seeing them in California. We saw a really interesting one in Virginia that passed recently that I think are going to have meaningful unintended consequences. The example in California, essentially the way the law seems to play out is, in order to protect reproductive rights information from law enforcement inquiries, it requires a segregation of the reproductive rights information from the rest of the medical record. Totally understand what they're trying to do, totally appreciate the goal. At the same time, I can look at that law and say, if what you're saying is every woman's medical records in California have to be segregated into two parts, I can tell you that there are people who are going to suffer medical harm because their medical records are incomplete. And I don't think that's obviously wasn't a goal of the California legislature, but I think that's a result of the law that they have because they were focused on point one without thinking about points 2, 3, 4, and 5. That's one of the geniuses of HIPAA is they thought about points 1, 2, 3, 4, and 5. And so I think we're going to see more and more of those laws that are designed essentially to respond to a particular situation. Right now, it's Dobbs related. We could easily see, whatever other development. You could see, there were some laws that, nothing as significant as Washington, but some things that came out of the COVID discussion. If we have some major societal development that's health related over the next few years, you're going to see laws passed in response to that. My concern is that the laws that are getting passed are just too narrow in what they are thinking about, and they're not broadly considering all the implications. And that's one of the hardest part about healthcare issues is that, there's so many societal implications of how healthcare data is used. If I go online and I buy a pair of jeans at the Gap cares about what I buy. I care about what I buy. Maybe Levi's also cares about. No average person cares about what I buy at the Gap. But the stakeholders in the healthcare privacy debate are much more expansive. You've got, government at every level. Government's a regulator. Government's a payer. Government's a healthcare provider. Taxpayers in general. The society in general. Employers care. I mean, again, my employer doesn't care what I buy at the Gap. My employer cares a lot about my healthcare because they're paying for a lot of my healthcare. And so, and even when you get into things like, ideas like consent, which are core elements of the privacy debate, if you have people consenting, for example, the day they turn 18 when they go to the doctor for the first time, if you gave them the right to consent about certain things, they have no idea what would happen 10 years in the future, 20 years in the future, 30 years in the future. They may want, they may think at 18, I don't want to have my data used for medical research, but they have no idea whether their data could lead to a cure for cancer that might benefit them 30 years in the future. So I just think that the interplay of interests is so complicated in healthcare. And again, it's a funny area because I think healthcare privacy, for whatever reason, gets less attention than many other areas of privacy. And we're seeing that play out in the national privacy debate, where, as I said, the healthcare industry is just not a part of that debate for the most part. I think that's ultimately going to be bad for the whole bill because it's not, again, the people that know the most about healthcare are not part of the discussion.
So I think this is a great place to wrap it up, and we could go on and on and on, but because there's so much to talk about, but we're getting on the hour, and I would have to kind of go into a whole new point or can of worms, whatever we might call it. I think, a couple things are, maybe we should, bring the HIPAA drafting team out of retirement to come in and help fix this non-HIPAA problem, create the HIPAA, the sequel to HIPAA for non-HIPAA world. But that could be many different worlds. It might not be just HIPAA, non-HIPAA. It could be HIPAA and like 10 other different categories. But it's definitely a big challenge that we're going to face going forward. And at least right now, I think you're right. We're going to see just this complicated landscape get even more complicated. I think the whole reproductive privacy front is a challenge when the interplay between decisional and informational privacy really comes into effect here. I think that both go hand in hand, and you kind of knock out decisional privacy, you have informational privacy implications that then you have to, if you put all the weight on that part, it makes it really hard and then complicates things for everything else. So there's a interrelationship with a lot of these different things that really hasn't been addressed. On the other hand, there are different contexts here with the information, and what privacy looks like in one area is different than something else. But it's so hard to define where one area begins and where one area ends. And health is so sprawling and so much implicates health. And the stakes for health are so high that this presents a lot of problems. I also find it interesting how health is kind of in its own kind of weird silo in the privacy world, that, there are privacy lawyers who will do everything except health. It's like, oh, suddenly like AI is big, and like within like a week they're an AI expert. I remember with the GDPR, all of a sudden lawyers who had never stepped foot in the EU, had no idea what was going on, suddenly became a GDPR expert. And they're like now experts on the laws around the world. But then you ask them about HIPAA and they're like, oh my gosh, HIPAA, no, I have no idea what that does. And so it's very weird that how like scared privacy lawyers are of HIPAA and of the health universe. And so there's this group of health lawyers like you who focus on this area, but it's interesting how it is somewhat siloed from a lot of the other areas, which are often lumped together. But maybe it should be more lumped together, because it seems that it's hard to solve this problem or do this. The takeaway point from what you're saying is we do need to kind of think of things more holistically, because they have effects holistically. What's done in these general laws for consumer privacy has effects for health and vice versa. So we need to kind of maybe unsilo this in somehow. But I
would not define the silo as HIPAA, because I think there's that's too narrow a piece, and it's too hard to pick up all that history. I think you could do health as a silo that's got to include all those other factors and all those other ingredients that we've been talking about today. I agree, there aren't people that specialize in that very much. There's a very small number of folks in that area. But as I said, the problem is that then as you broaden that out, it now blends into everything else, and it becomes not necessarily unique. And that's really the challenge. I mean, the more of these laws that define a broader range of information as health information makes it harder and harder to come up with a distinct idea of what health is. And so that I think that's the biggest problem created by this current group of laws that are looking at things like inferences. And once you've got an inference, it could be anything. And once it's everything, it's not really healthy.
Well, on that note, now that we've solved it all, thank you so much. It's been really fun chatting with you, really insightful. And